My topic of choice is the need for speed. Is arbitration becoming overly fixated with efficiency? As you will know, efficiency is often cited as one of the main advantages of arbitration over court litigation. Court litigation, of course, being highly regulated, often with one or several layers of appeal. Arbitration being hardly regulated at all, and of course being a one-stop shop, provides a lot of gains in time and cost. And business, of course, often need to have their disputes resolved sooner rather than later. They need that because they need legal certainty. They need to know what their position is so they can plan ahead. And they also rather grow their business than spend time in courtrooms or in arbitration venues. And for international commercial arbitration to maintain its attractiveness, of course, it needs to cater for these needs of business. No doubt about that. Now, I've been an arbitration lawyer for over 20 years, and during all my time, there's been a debate going on amongst our clients and users about the time and cost of arbitration. So nothing new there. And speaking to older colleagues, it's clear that that discussion dates back much longer than just 20 years. It may even date back as long as arbitration has been around at all. However, it seems to me that the focus on efficiency as to time and cost have gained increasing focus and sometimes even singular focus in recent years. In this respect, of course, arbitration is really only following a much larger global trend where things need to go faster and be cheaper all the time. Since its origins, international commercial arbitration has changed into a global professional industry. As part of that development, it seems to me that every other country now is developing a modern arbitration law and also setting up one or more institutes to try to gain the business, not only in that country but in the surrounding region. As a result, of course, and over time, competition between arbitration seats and arbitration institutions are constantly increasing. And in trying to attract users and grow their business, they need to improve their offer constantly. A large, if not even predominant part of that effort and that offer is trying to limit the time and cost of bringing a claim to arbitration. By way of example, very recently my own government introduced changes to the Swedish Arbitration Act, the majority of which I would say are geared towards achieving efficiency. For instance, by limiting the time that a party has to challenge an award from currently 3 months to 2 months. That's just an example. There are many other provisions in the draft. Institutions, of course, are taking similar measures, but much more often. They revise their rules every 2-3 years, looking at other institutions, looking at what's happening in the world, trying to keep ahead of everyone else. And they will, a large part of their efforts in revising their rules will be to make them more efficient. If you look at the most recent revisions of the ICC rules, the LCIA rules, the SCC rules, which were changed as late as 1st January 2017, you can see that the bulk of what's happening is geared towards efficiency. Efficiency is pervading more or less every step of the procedure, trying to make it quicker and perhaps cheaper. Not that the institutions are lowering their fees, that's not happening, but they're trying to make the council cost less, I assume. In addition, you'll also see that most legal institutions are now regularly providing statistics over the time and cost it takes to bring a claim. And this, of course, is helpful to them. They can measure, they can compare, and they can make it part of their marketing. I will go on to give you 3 examples which I consider relevant as indicators of this development, or if you wish, signs of our time. I should say outright that I do not consider any of these examples to represent clear-cut infringements of fundamental principles of arbitration, and there are aspects of them that may even be beneficial, for sure. However, the common theme for all 3 is that they are almost singularly driven by efficiency as the underlying factor. They are otherwise quite disparate, but that is the common theme of them all. And they all raise questions, I submit, as to how far we should really allow efficiency to guide our choices in international arbitration, and what other values may potentially be sacrificed on the way. My first concept is the concept of due process paranoia. Now, I do not know who coined that phrase, but it's become very popular since it was coined. Due process paranoia, you will know, or at least I will explain to you, is the idea that arbitrators are generally harboring exaggerated fears of their awards being successfully challenged on the basis of a party not having been given the chance to fully present its case. And arbitrators, supposedly suffering from these paranoid tendencies, they will lack decisiveness. They will show an exaggerated generosity in procedural decisions, resulting in increased time and cost of arbitrations. It's been recognized that from a strict legal perspective, due process may only really be infringed if a tribunal severely misuses its procedural discretion. So it's a very high threshold before you can say that you've abused someone's due process rights. And the result of this is that for the majority of procedural decisions, there is what has been called a safe harbor, where one cannot say that they infringe on due process rights. So that should be a comforting thought. Second, there have been statistics shown, at least for arbitration-friendly jurisdictions, demonstrating that it's very rare, in fact, for procedural irregularity to be a successful basis for a challenge. Again, something that arbitrators, at least those operating in arbitration-friendly jurisdiction, can take some comfort in. As I've said before, I think it's been generally helpful, and I have no doubt that some arbitrators do have exaggerated ideas of the risk of challenges. I question the general applicability of this diagnosis to the majority of procedural decisions where a tribunal may perhaps appear to be overly generous. There may, I would submit, in many cases be a differential diagnosis, which is simply prudence. And the reason why I'm saying this is that I believe that if you take a broader view on fairness and on long-term risk management, you can see that there may be causes sometimes to be a bit more generous, and the parties may not fully appreciate this. Among those considerations taken by some arbitrators, and I should say that I'm one of those, but rarely if ever explained to the parties, include the following 5. First, on a very general note, as I said at the beginning, arbitration is a one-stop shop. It's one of its benefits, but it also means that you won't get a chance to argue your case before a second higher authority. Given that limitation, I think it is incumbent on arbitrators to give parties a reasonable chance to have their full day in court, especially for the losing party to feel that he or she wasn't unnecessarily prevented or curtailed in presenting its case. Second, a losing party, and typically you have a losing party, will almost inevitably feel some level of dissatisfaction with that outcome. It's pretty obvious. And this substantive dissatisfaction, I would say, becomes even worse if it's coupled with a procedural dissatisfaction. If a losing party is left believing that he or she might have won, had they only been allowed to present that final submission, had they only been allowed to introduce that late witness, which they thought was timely under the circumstances. If a losing party is left with that feeling, well, that losing party is probably much more prone to go on and launch a challenge against the award. Third, even if you accept the statistics from arbitration-friendly jurisdictions that the risk of a successful challenge is a low risk, if that low risk materializes, it can be devastating, of course. It can make the entire investment of time and cost in the arbitration absolutely useless. Affording the losing party some procedural generosity may be a small price to pay if that can reduce that risk. It may be comparable to paying a small insurance premium against a highly unlikely but devastating event. We do that all the time. We insure our homes against unlikely things like fire. We accept that. Fourth, even if you simply assume that whatever challenge is being launched afterwards is likely to be unsuccessful, so you're not afraid of a successful challenge, it still makes sense to avoid it altogether. Because what happens if you're the winner of an arbitration, if the losing party challenges your award? Well, two things. One, of course, is that it introduces uncertainty about the continued validity of your award whilst that challenge proceeding is ongoing. And second, it forces you to defend the award, and you will have to invest substantial amounts of money in legal costs as a party to defend the award. At the end of this, and this may take many months or even years, depending on the seat where the challenge is made, you may not recover all those costs. In some jurisdictions, you don't recover your costs, at least not in full, before the courts. And even if you do recover, you may not be able to enforce a cost order. And fifth, the risk, of course, of successful challenges or the risk of successful refusals of enforcement will vary between different jurisdictions. Most of the statistics that have been invoked are about arbitration-friendly jurisdictions, but not all jurisdictions are arbitration-friendly. I live in a part of the world with Russia and CIS countries where the arbitration friendliness do vary quite a bit. As arbitrator, you need to take that into account, that you may end up before court in a country where they're not particularly arbitration friendly, and you don't want to give them the opportunity to decline to enforce the award because of some petty thing that you'd resisted when it came to, let's say, additional evidence. At least it's something you will consider. Now, these factors are not exhaustive, and you always need to balance them against other factors, including, of course, time and cost. But if you take them into account, you may realize that the short-term addition of some time and cost from a generous procedural decision may well be outweighed by a long-term reduction of risk for even greater losses and time. And furthermore, of course, if the party who is dissatisfied with this procedural decision being too generous, if that party ultimately wins the arbitration, well, at least you can compensate that party for the added cost of that generosity by ordering them full compensation for their legal costs. My overall conclusion on the debate on due process paranoia is that this singular focus on efficiency, and particularly short-term efficiency, may lead to short-sightedness when it comes to risks and costs, and it may lead parties to sometimes confuse an arbitrator's prudence for paranoia. Moving on to my second example, it is something called the Prog Rule. Now, what are the Prog Rules? Well, you'll be familiar, I would assume, most of you, with the IBA rules on the taking of evidence. They were introduced in their latest form in 2010. There's an older form, I think, from 2004. They've been hugely successful in creating a common framework around the world for the taking of evidence, including production of documents. And the reason, of course, why they've been so successful is that they strike a very good balance, a compromise between common law and civil law systems. As a US lawyer, you don't get full-blown discovery. As a civil law lawyer, perhaps from Germany, you get a bit more production than you would perhaps in your court rules. But still, the balance is acceptable to both camps. And it's been generally heralded as a big thing in arbitration that you have this. It also saves time and cost, because what you'll find is that parties are ready to adopt it without much discussion at the beginning of an arbitration. So this caters for efficiency. It has value. Up comes a contender, the Prog Rules. What are the Prog Rules? Well, at the moment, they are merely draft rules. They're going to be adopted in Prague, hence the name, later this year. As you can see, They promote themselves as the rules on the efficient conduct of proceedings in international arbitration. Again, you see the recurrent theme of efficiency. So, why have they come about? Well, the authors are a group of predominantly Russian lawyers and lawyers in neighbouring East European countries. Now, these are countries where, before the local courts, they've been a tradition of taking an inquisitorial rather than adversarial approach. So you'll have the judge deciding what evidence to acknowledge or not, the judge to be the driving force in assessing the facts, and generally a skepticism against oral arguments and oral witnesses. So they prefer a written procedure. Now, inspired by these inquisitorial system, they come up with these rules. And if we take a little bit of a look at what the rules would entail, for production of documents, if you are familiar with the IBA rules, you'll know that they allow you to ask for a reasonably defined but still category of documents. You don't need to specify the particular document. It's enough that you can, with some accuracy, say, you know, it's correspondence between X and Y in this period relating to this particular subject matter, and it can be by letter, email, or whatever other form. That would typically be sufficient if you can persuade the arbitrators that it is relevant and material. It will not be sufficient under the draft Prog rules. You will need to specify the particular document in question. Essentially, that means that you need to know what you're asking for. Second example, witnesses of fact. Well, the Prog rules takes a restrictive approach to witnesses of fact. It says that it is for the tribunal to decide which witnesses of fact will be heard. Effectively, this means that you can submit witness statements for all witnesses, but then the tribunal will decide. Typically, under the IBA rules, the opposing party is asked, do you want to cross-examine this witness? Do you want this witness to be called for cross-examination? And then you say yes, and then you get the opportunity to challenge that witness, the testimony of that witness statement through cross-examination. Here, you're not assured of that right. The tribunal may think, no, we already have so many witnesses saying the same thing, or we're already convinced about those facts, or, oh, we don't believe him or her anyway. Whatever reason, they may say no. No, we're not going to hear that witness, but we'll still allow the witness statement to stand. Well, as you may have guessed, I'm not a fan of these rules. I believe they should be resisted. And again, I think they're coming out of this idea of promoting efficiency, but they are really doing something else and sacrificing something else that is more valuable whilst doing that. First, of course, it risks leading us back to a situation where we don't have this common framework anymore. We will need to have big debates between counsel at the outset of every arbitration, which particular set of rules are we going to be guided by, and if so, which parts. All that will go against efficiency, I would say, and also make arbitrations less foreseeable. Secondly, if indeed document production and the hearing of fact witnesses and party-appointed experts add substantially and perhaps too much sometimes to the time and cost of arbitrations, I would say that's not the fault of the IBA rules. That's the fault of parties and particularly arbitrators for not sufficiently planning and managing the process. That's when you typically see that it goes south and you end up with protracted situations adding unnecessary cost. My third example is the ICC expedited rules. Now, before I embark on this, I should say, and I think Steve mentioned that, I'm a proud member of the ICC court. I also believe that the ICC is a very good institution, perhaps the global leader, and I also believe that the rules are very good. I'm happy to refer to them in arbitration clauses. That doesn't mean that I cannot be critical of some aspect of the rules, same as I could be critical of any rules. There's always something that you can find to be critical about. And in this case, I'm a little bit critical about the ICC expedited procedure that came into force on the 1st of March last year, i.e. 1st of March 2017. Now, the idea, of course, with expedited procedure, as you will appreciate, is again efficiency. You have the ordinary rules and then you try to change them in some way to benefit efficiency, to drive down time and cost. Now, typically, institutes will have expedited rules. The SCC has got expedited rules, many other institutions. But the way they typically go about that is that they leave it for the parties to choose. If you go to the SCC website, you'll see you can choose the ordinary rules, or you can make a choice to directly refer to the expedited rules. You have this choice as a party. You know what you're getting into. It's your choice. The ICC is taking a different approach to this. They've decided that, no, you just refer to the ordinary rules. And if you make this reference in your arbitration clause after 1st of March 2017, i.e. when this expedited procedure had come into force, they automatically apply if the dispute, which of course you may not even have contemplated at the time you wrote the arbitration agreement, if that dispute comes out being at a value under a certain threshold. So when you write the clause, you're probably quite ignorant about all this, you just refer to the ICC rules. You happen to make that clause after the 1st of March 2017, and then you happen to have a dispute where the value is, let's say, 1.9 million, which, because the threshold is $2 million. Then you're in the expedited procedure. Surprise. Now, the big thing about these, which do make me hesitate a little bit, is that what they say is that if they apply, if you have these circumstances, and that's what I've highlighted in yellow there, it says, by agreeing to arbitration under the rules, the parties agree that this Article 30 and the expedited procedural rules, set forth in appendix this and that, shall take precedence over any contrary terms of the arbitration agreement. So you have this party who may be pretty ignorant about all this. They've made a specific arbitration agreement, included certain features in there, but if they're not compatible with this procedure here, they will be ignored. Then you have the dispute arising, $1.9 million. You get the question from the Secretariat. The court is contemplating to nominate a sole arbitrator because you are now in the expedited procedural rules. What's your comment? And then your opposing party says, we're fine with that. Because if both parties agree, the ICC are not going to do it. But if only one party disagrees, as a general rule, they will say, well, the expedited rules will apply. We will appoint a sole arbitrator. Now, if that party who wanted to nominate its own arbitrator then end up losing the arbitration, that party may well feel a little bit dissatisfied, perhaps believing that it could have turned out differently had he or she only got the opportunity to do what the arbitration agreement said, which is to nominate an arbitrator of its choice. That party may be more prone to challenge the award and perhaps try to resist enforcement. And it may be helped. Because if you go to the New York Convention, and if you look at Article 5(1)(d), it says, recognition and enforcement of the award may be refused when, and here comes, in the D clause, the composition of the arbitral authority, that is the arbitral tribunal, was not in accordance with the agreement of the parties. With these three examples, I've tried to illustrate to you what I perceive to be a growing tendency in international commercial arbitration to be overly focused on efficiency, sometimes at the expense of other important principles and values, be it general fairness and long-term risk management, as in my example of the due process paranoia debate, be it a common global framework and an adversarial process, as in the example of the Prog Rules, or be it party autonomy, as in the example of the ICC expedited procedure. By no means, and I want to be clear here, am I saying that efficiency is unimportant. On the contrary, it's likely vital to the long-term survival of international commercial arbitration. However, it always needs to be tempered by other considerations, including those principles and values that I've mentioned. Just because those principles and values are less tangible and cannot easily be measured and compared doesn't mean that we won't sorely miss them if over time we allow them to become devalued or eroded in the name of efficiency. Thank you.